Welcome to this special webinar, Whistleblowers, War Crimes and Press Freedom, David McBride on Trial. This event is brought to you by the University of Queensland's T.C. Burney School of Law, and I'm Professor Peter Grester, your moderator for this evening's discussion. While I'm not a law school academic, I have been doing a lot of thinking and writing about the intersection between press freedom and national security, along with one of our speakers this evening, Dr. Rebecca Ananian-Welsh. Firstly, though, let me acknowledge the traditional owners and their custodianship of the lands on which we're all seated. We pay our respects to their ancestors and their descendants who continue cultural and spiritual connections to country. We recognise their valuable contributions to Australian and global society. Now, before we get the discussion underway, there are a few housekeeping points I'd like to mention. All attendees are muted for the webinar and you won't be able to share video. But if you do want to ask a question, please do click on the Q&A icon down at the bottom of your screen, and I will do my best to raise these with the panelists. Closed captions have also been enabled. You can turn this on if you wish by pressing the double C button on the bottom panel. Watching the captioning, of course, is always good for a giggle. Most of you will remember that David McBride was the whistleblower who leaked classified documents to the ABC with allegations of war crimes committed by Australian Special Forces in Afghanistan. Now, he's being prosecuted for leaking classified information. And when we first began discussing this session, his trial seemed imminent. It's since been pushed into next year, but his case still raises a lot of very difficult questions about press freedom, whistleblowers, and national security in Australia today. So, let me begin by introducing our panellists. Dan Oakes is a senior reporter for the ABC and one of two journalists, alongside Sam Clark, who published the original Afghan Files story based on the documents that McBride passed to the broadcaster. Dr. Rebecca Ananian-Welsh is a senior law lecturer here at the law school. She's a constitutional lawyer, but I've also been working with her on some deep dives into national security legislation and press freedom. Kieran Pender is the senior lawyer at the Human Rights Law Centre and an honorary lecturer at the ANU's College of Law. He's also been an outspoken advocate, of course, on human rights issues and transparency and accountability. And finally, Fiona McLeod SC. She's on the Victorian Bar and she's also chair of Accountability Roundtable and a former chair of Transparency International Australia and the Open Government Forum. She has also written a book, Easy Lies and Influence. That's on corruption in Australia, and it was published only a few months ago. Available, of course, I'm sure, in all good bookstores. So let's begin with the discussion. Kieran, I'd like to begin with you. Our federal whistleblowing law explicitly allows whistleblowers to go to the media. So why on earth is David McBride on trial? What does this case tell us about the state of whistleblower protections in Australia?
Thanks, Peter. That's a fantastic question. I think the prosecution of David McBride underscores really significant shortcomings in whistleblower protection in Australia. As you say, our whistleblowing law, and this particular case, the Public Interest Disclosure Act, recognises the role that media plays as a safety valve when efforts to disclose wrongdoing internally fail to address issues. But despite that express empowerment for whistleblowers to lawfully speak to the media in appropriate circumstances, the legislation is so complex. It requires whistleblowers to jump through so many hoops, so to speak, that the promised protection may, I think, in fact, all too often be a facade or a mirage. That's exactly what happened in the present case. David McBride sought to raise concerns with his superiors, with the Inspector General, and even with the Federal Police. The PID Act says if all else fails, you are then allowed to go to the media with some caveats, I should add. So that's exactly what he did. Only now the Director of Public Prosecutions is saying, no, actually, you didn't quite jump through the right hoops. And so therefore, rather than having the full protection of the law, you might go to jail instead. I think two things can be said about that. The first is that the prosecution of McBride is not in the public interest. If he succeeds in the first dimension of his trial, being the PID Act's defence, which was supposed to take place this month and has now been postponed, if he proves that actually he did jump through the right hoops and therefore has immunity from prosecution, That would highlight the absurdity of this case being brought in the first place. And alternatively, if, as the DPP say, he loses his defence, which would effectively be on a technicality, despite the clear intent of whistleblowing law to establish a pro-disclosure, if in doubt, speak up culture, that really runs in the face of that legislative intent. And I think the second point is that the prosecution really highlights the urgent need for this law to be reformed. 5 years ago, an independent review told the government the law needed to change. Like federal court judges have described the PIT Act as technical, as obtuse, as intractable. It's unconscionable that the federal government has watched over the prosecution of McBride and fellow whistleblowers like Bernard Collaery, like witness Kay, like Richard Boyle, and indeed, in the case of Collaery and Kay, even gave explicit consent for the prosecutions to proceed while sitting on reform that would enable Australians to safely and lawfully speak up about wrongdoing. Whistleblowing is a public good, and I think prosecuting whistleblowers like David is not.
There are a whole host of issues that you raise there, and we'll come to a few of those later. In particular, I think the question of law reform. And we seem to have lost Dan. I'm not sure, Dan, have you got your video there? You're still there. Fantastic. Dan, you first worked with David McBride to expose the Afghan Files for the ABC, and it strikes me that there is a strange irony here that of all of the people associated with the allegations of war crimes in Afghanistan, the first person to face trial is the man who blew the whistle.
There is a certain element of irony in the fact that it should never be forgotten that the very first person that blew the whistle on war crimes and reported on war crimes was back in 2016. That was a colleague and friend of mine, Andrew Green, for the ABC, and he interviewed a commando called Kevin Frost back in 2016, and Kevin Frost said that he had witnessed and was complicit in war crimes. Since then, since 2016, so in the 5 years since, we've obviously done stories. There's been some fantastic reporting done by Nick McKenzie and Chris Masters at the 9 newspapers, and I'd say most outstandingly by my colleague and friend Mark Willesee at the ABC, who obviously won a Gold Walkley for his story, The Killing Field, which showed the alleged murder of an Afghan man in a field in Afghanistan. So that's 5 years of reporting on war crimes, so sometimes with first-hand testimony and first-hand witnesses. And as you say, it is quite extraordinary that the only person so far who's been charged is the person who has spoken up about alleged war crimes having been committed.
I do want to ask you, and I will come to you in a moment, to talk to a little bit about the chilling effect that these kinds of trials and prosecutions are having on the kind of journalism that you do. But before we do that, I want to ask Beck. Secrecy, of course, is going to be a central theme of this coming of McBride's trial, and we'll discuss some of those charges he's facing later. But I know you're expecting a lot of the trial to be held in camera. Isn't that appropriate for a trial that covers a lot of national security issues? I mean, that's why the NSI Act exists in the first place, isn't it? To make sure that classified information remains classified.
Well, look, you could classify me as a skeptic. I have been operating in this field long enough and have dealt with enough of these kinds of issues to know that there are people out there who believe things should be kept secret. And I think we should question whether those things should be kept secret. I think I've picked up enough along the way to know that we shouldn't just be satisfied when we are told these things need to be secret. We should question that. I really think that I really think we should be questioning the need for secrecy.
Rebecca, you've been having a look at the NSI Act as well. What are your thoughts on this, on the question of secrecy?
What's already coming out of this discussion 5 minutes in is that this whole case is emblematic of that tension between secrecy for security, which is needed, and openness, transparency, accountability, calling out misconduct. So there is that tension there, and documents are classified for good reasons. And one of those reasons is that people will be hurt if you reveal that information. But then does that mean it should never, ever, under any circumstances, see the light of day, even if it reveals serious misconduct? So that tension doesn't stop at the courthouse steps. You mentioned the NSI Act. So that's a scheme that was introduced in 2004, so in the wake of 9/11, really, to introduce...
The NSI Act is the National Security Intelligence or Information Act, isn't it?
National Security Information Act. But don't let the title deceive you there. National security under the National Security Information Act is defined so broadly that it basically encompasses all of Australia's international affairs within that kind of scope of national security. So national security information is a broad scope of information that journalists deal with all the time. So what that act does is it allows for secret evidence. Before the NSI Act, if you wanted to rely on classified information in court, you had to do it openly. Or you faced a choice of not relying on it at all and trying to prove your case without that information. The NSI Act allows a prosecution to rely on the information as evidence, so the judge can base their decision on it, but that won't be seen by the public. It may not be seen by the jury. It may not even be seen by the accused or by their lawyers. So this is just can happen privately between the prosecution and the judge. And for someone like David McBride, Witness J, Witness K, Bernard Collaery, you can face some pretty serious consequences without knowing the full scope of the information that's used against you. So some of that secrecy could be major. And I think we're going to see that in the McBride trial, because let's face it, the whole thing is about national security information. So that could be completely closed hearings where everyone is shut out, including potentially David McBride himself and his lawyers. So that's very disturbing, and it places a lot of emphasis on the judge. Really, the public and everyone who would usually have a scrutiny role over court proceedings isn't there to have that role. So it's just down to the judge. But even the technical kind of secrecy that's easily overlooked, like the documents have to be kept in a certain safe, they can't be transferred over unsecure networks, means that you can't discuss things by email and things about these documents. Nowadays, when everyone's in lockdown, that's making preparing a case extremely hard. So even low levels of secrecy are some of the reasons why David McBride's trial is being delayed, not by weeks or months, but by years. He's facing this kind of prospect of potential charges. So yes, secrecy is absolutely important, but it comes at a huge cost and it places a lot of emphasis on scrutiny.
Thanks very much, Rebecca. Fiona, I've got a couple of questions that spring from some of Beck's comments there. I guess the first is the more specific one. As a practicing senior counsel, how do you find out? Obviously, I don't want you to deal specifically with McBride's case, but generally, are you concerned about the level of secrecy that's been entering trials? How difficult is it to act in these kinds of cases when there is that level of secrecy involved?
Absolutely, Peter. Secrecy, including the prohibition on an accused having access to information supporting charges, is an absolute anathema to a fair justice system. To require an accused to trust a judge and not even have their representatives, their lawyers, have access to information that may or may not be based on intelligence of variable quality undermines the way that we do justice in this country and a fundamental underpinning of our sense of that we're all being accorded justice in this country. And don't forget, in many...
I mean, sorry, aren't there, but there is a higher national interest in protecting that information. Surely, I mean that's why those exist, and don't you have to accept that as a necessary price to pay for these kinds of trials?
That decision, let's not forget, is also not subject to scrutiny. So in cases like the Bankleri Witness K cases, the Attorney General authorised or certified that matters were in the national, that matters of national security and therefore shouldn't be revealed. And then the legal team had to bend over backwards to try and have access to that information so they could understand and digest and respond to it. That certification itself is not subject to scrutiny. It's utterly unaccountable. And the risk in all of these cases is that it's subject to being influenced by ideology or political objectives. So we have to protect against that risk. And we've seen the mantra of national security being rolled out to justify an unprecedented expansion of national security powers in Australia. The laws that have been rolled out since 9/11 give our national security agencies, so that is intelligence gathering and law enforcement, greater powers and cumulatively more massive powers than even they had during the operation of the Cold War or the immediate aftermath of 9/11. So that's the situation we're in. And it's happened incrementally in Australia with very few noticing and voicing their concerns. You know, the Law Council of Australia and human rights institutions being notable exceptions to that. But these powers reach across physical and cyber activity. They include control and access to our metadata, data that's harvested by third-party corporate entities. They include their application to children, the erosion of the practical ability of lawyers to represent clients by removal of information, removal of clients. They hamper journalists' ability to report stories and to do so without fear of prosecution. And they hamper the public right to know what's being done with these powers. So we're given an assurance that these powers are necessary, but then we wind back the scrutiny mechanisms, including the form, you know, the effective and mostly apolitical operations of joint parliamentary committees on intelligence and security, who do a very good job, but are often ignored when there's pressure for new laws to be passed.
But Fiona, we don't have anyone from the government on this panel, so I'm going to have to sort of push you on that. Anyone who went through 9/11 who remembers, of course, we've got a whole host of pieces reflecting back on the last 20 years and the effect that that's had on us all. But the politicians there was a very powerful political incentive for politicians to pass legislation that would keep us safe. And in a world where cyber crime and terrorism is rife, and where criminals and terrorists are capable of using all sorts of encrypted apps and secret communications devices, surely we need to give our security agencies these kinds of powers to prevent further attacks. And the fact that we haven't had any attacks, some supporters of the government would argue, is evidence that it's actually worked.
Look, there's no question that these powers, or some of them at least, a selection of them, have been useful in providing law enforcement agencies with advance warning that has enhanced their ability to respond to threats to public order and in some cases have not assisted them so that they haven't responded in time. But what needs to be borne in mind is that regardless of whether they're a good thing or not, they do authorise a very intrusive surveillance of citizens with a very minimal justification and next to no scrutiny. And the rationale for them depends upon both that protective necessity that you're talking about, but also the intrusion of an ideological or political motive. Because, of course, we recognise that a population that is more willing to give up its personal liberties, if they are afraid, they're more prepared to give up personal liberties. And they're also a population that is easier to manipulate in an election, for example, through selective release of information or misinformation and constant hints about the enemy of one sort or another, and the endless stream of military appearances on our daily lives and daily news briefings. So that's the context. And these laws authorise secrecy and a lack of political accountability for the exercise of that power. So what my point is that the risks of misuse are enormous in terms of abuse of in terms of the loss of our privacy and in terms of normalising state intrusions into our daily lives.
Dan, I saw you nodding vociferously there. As a journalist who covers the government, do you agree with Fiona? You're on mute, Dan. You're on mute.
Peter. I feel like we should always question. Yeah, we should always question what we are being told that we should not know. And I feel like if you'll indulge me, if we talk about the Afghan Files and the stories that we wrote, we did a lot of stories about inquiries that were done into incidents in Afghanistan and killings that occurred in Afghanistan. And we did those inquiry reports were classified as Australian eyes only, or classified documents. They were secret documents. But what's come out, as a result of the Brereton inquiry and what's come out subsequently is that a lot of those reports and a lot of those inquiry reports weren't worth the paper they were written on. Yet someone somewhere has decided that those reports were classified, secret, nobody should be allowed to see them. But now we know through the Brereton inquiry that they really weren't, a lot of them weren't worth the paper that they were written on. So I just feel like we should not be told by people what we should and should not know. I think someone somewhere is telling us what we shouldn't know, and we should always question that.
But you're arguing for a very broad interpretation of transparency, as a journalist, it's hard for me to disagree with you. But again, let me put a government hat on and argue that classified documents are classified for a reason, and it's not always immediately obvious to those that are outside. It's possible for people who are able to collate various pieces of information to put things together and come to conclusions, and only those who are really familiar with the documents intimately would understand that those of us outside the security system simply aren't capable of making those judgments.
That's true, but I feel like we should never just take that for granted, though. We should never just accept it at face value. We should never just assume that others know better than us, and we should be told what's best for us. We should have that capacity and ability to be able to make decisions for ourselves. And we were criticised for publishing some of those inquiry reports. There are people out there who I won't name who wrote those inquiry reports who have been highly critical of us for having published them and said they were classified reports. You had no right to publish those. But I'm comfortable with the fact that we published them because, as I said, the Brereton Report, the Brereton inquiry has subsequently shown that some of those reports weren't worth the paper they were written on.
Peter, if I can just jump in, I think I appreciate you sort of have the devil's advocate hat on, but I think what you're getting at is a complex tension that's not novel. I mean, we've been trying to balance secrecy and transparency for hundreds of years, and the courts have evolved sophisticated mechanisms to balance these different interests. What I guess is the concerning issue in the last 2 decades is that the thumb has been pressed on the scale in favour of secrecy. So in the NSI Act, for example, as we said, the Attorney General has an unreviewable role to certify certain cases, and then the Act says the court has to give greatest weight to the Attorney General's view, not great weight that can be equally balanced with a whole range of multifaceted factors, but greatest weight. So, I certainly don't disagree that sometimes there may be circumstances where an appropriate level of secrecy is justified and justifiable. I accept that in some cases surveillance powers might be necessary, proportionate, and have sufficient safeguards. But what we have at the moment is, in both of those cases, is not that.
We're in a situation, and Kieran, while you're there, I might as well keep the question with you, where Dan and Sam Clark, the two journalists, Dan's colleague, were also threatened with prosecution. In fact, Sam at one point was facing charges, and the fact that those charges were dropped, the fact that Dan is able to talk to us, the fact that those issues are now clear, doesn't that suggest that that the system, at least to some extent, actually works?
I think it's quite problematic. What has transpired. The raids on the ABC should never have happened. The law needs to recognise the really important role that journalists and whistleblowers play, and that role needs to be recognised at a preemptive level. Because what instead has happened has been that this threat has hung over ABC journalists, including Dan, for some time. It continues to hang over David McBride. And the chilling effect that has is really undercuts the important function, the vital democratic function that public interest journalism and whistleblowing plays. If you were a whistleblower and you saw what has played out with the prosecutions of Bernard Collaery, David McBride, Richard Boyle, Witness K, would you then choose to go to a journalist with information that's in the public interest? Despite the fact that in all of these cases, the information has been true. No one denies any of what has been sort of said by these whistleblowers, allegedly, and no one denies that that was in the public interest. Well, at least not, I think, all of us collectively would say that what's been revealed has been eminently in the public interest. So I think that the chilling effect indicates that the law is limited, and the role then of for example, government in making some of these decisions, the role of the Attorney General in consenting, it adds a politicisation to these cases that makes them extremely problematic.
Let me ask you, Dan. Do you feel that chilling effect?
Ultimately, Peter, they elected not to proceed with charges against Sam and I, and they basically said to us, "We don't believe that it's in the public interest that you be charged." They made it pretty clear that if we had been charged, that they were confident that they would have obtained a prosecution. It was not by any means you're in the clear. I certainly don't take any great comfort from the fact of what's happened to me.
But if they've decided, if they've explicitly stated that it's not in the public interest to charge you, doesn't that show then that the system does have some integrity?
But that's just an arbitrary political decision, though. Really, I mean that could be that's all dependent on one person sitting in an office somewhere saying, "You know what? No, we're not going to do it." It's not a systemic or a structural solution to the problem.
Fiona, just on some of I want to pick up on one of the charges that David McBride is facing. And again, I realise that you haven't looked too deeply into this, but one of the charges he's facing is theft of Commonwealth property. That sounds like a creative use of the Crimes Act. Does that mean that any whistleblower who gets hold of a document could find themselves on those kinds of charges? It just seems like a really interesting abuse of the Crimes Act for a purpose that it was not ever intended for.
Well, without commenting on David's charges, of course, which are proceeding, a prosecutor has to decide. Police gather evidence, admissible evidence, and these laws are being used to, these national security laws are being used to do more than that. They're being used to gather intelligence, whether it's admissible in support of a charge or not. So we can come back to that at another time perhaps. But what all directors of public prosecution need to do is be guided by two fundamental preconditions to commencing and continuing a prosecution of a charge. The first is that at all times they are satisfied there's reasonable prospects of a conviction. And secondly, that the prosecution is in the public interest. Now, to have a charge of misuse of a government document be the charge reflects the fact that perhaps they were looking around for a way to control how government documents are used. Somebody's decided there's technically a breach here, but they have to then decide, is this prosecution in the public interest? And you'll remember the Bernard Collaery Witness K charges sat on George Brandis's desk for a very long time before there was a change of the Attorney General, and Christian Porter then authorised the prosecution. So there's a different view, obviously, or a discretion about what's considered to be in the public interest. And the danger is that what guides that decision from a DPP's point of view is pretty clear, but what guides it from a politician like the Attorney General's point of view is obviously subject to political motivations and the risk that those will intrude, political objectives will intrude into the exercise of that discretion. I just wanted to pick up on something, if I may, that Dan said then too, and put this in context. The powers that we're talking, the features of this chilling effect that's being spoken about also include things that are less visible. They include the shift from gathering admissible evidence capable of supporting charges to intelligence gathering, the shift to the intrusion in all manner of crimes, not just the most serious crimes like terrorism or child abuse, for example, the erosion of judicial oversight for the issue of warrants so that warrants can be issued by the AOT or tribunal members as opposed to experienced judicial officers. And let's not forget that they're said to be necessary contrary to the views of those who have conducted reports into these laws. So independent monitors, and I include in that the former head of ASIO, Dennis Richardson, in his report. And nevertheless, we're told these laws are necessary, and so they're introduced and passed.
Beck, there is an obvious, we're in this sort of situation, and we'll move on shortly from this tension between secrecy and public accountability. But there is a difficult balance and an obvious tension between what the intelligence agencies, the security sector would argue is a very obvious public interest in protecting classified information against what could be described as a far less tangible public interest in accountability. How do we balance that tension?
It's $1 million question, isn't it? Something I've been thinking about, listening to everyone else and the points you've been raising in that one as well, is that, look, there is misconduct under these laws. We know that it happens, and we know that it needs to be called out. So we need accountability, and we just need accountability in a democracy to know who to vote for. The question is, at what point in these processes do you get that accountability? And what's happened in the trend of national security lawmaking since September 11, which has seen us go from no national counterterrorism laws to 92 in 20 years, is don't worry, trust us. Here's a very, very broad law with very discretionary wide powers under it. A lot of them are exercised covertly. We're going to have secret trials, and we're going to have secret access to your data, and we're going to have all of this stuff happen. Don't worry, you need it, and you can trust us to exercise it properly. And where there are protections, they're down the line. So we'll investigate you, we'll consider charges, we may even take you to court, but don't worry, at some point somebody's going to make a decision about whether or not it's in the public interest to prosecute you. So it's pushed way later, the accountability mechanisms. What you see in every other Western democracy is rights written into some sort of national instrument, so that right from the outset, the Parliament has to be considering, can we get this through? And quite frankly, you wouldn't get warrantless access to metadata in the EU because you can't, because of privacy rights. You wouldn't get daylight raids on the national broadcaster in the US because everyone would jump up and down about the First Amendment. So it's front-ended everywhere else in the world. We could use a little bit more of that front-ending. We could use a little bit more written into the actual laws at the beginning so that Dan can go out and get the story and know that he's protected as he writes it, or the whistleblower can be clear that they're protected before they go to the journalist, rather than thinking, I might be right, because I'm pretty sure that the Attorney General, when prosecution against me lands on his desk, will think that it's not in the public interest.
Yeah, you and I have often had discussions around the chain of disclosure from all the way from whistleblower through to publishing, and that it doesn't matter if you protect the journalist if the whistleblowers are exposed.
Yeah. So that chilling effect that we've all been talking about, it's great to hear people talking about the chilling effect because it's so intangible and so insidious that it's kind of hard to talk about, but it's what's really bad for democracy. Isn't just journalists being scared of going to jail. A lot of journalists, I think, would kind of a little bit, well, I don't want to say it to you, Peter, but love to go to jail for the sake of a good story. But it's about the source at the very outset, seeing something go wrong and being too scared to tell anyone because they might go to jail or they might get fired or any kind of repercussion or victimization might happen to them, or they're not sure. So from that very initial stage, all the way through to the first person they talk to, the internal disclosure, do they go to the journalist? Does the journalist say this is too risky? Does the editor say this is too risky? Through to publication, there's a lot of ways that chilling effect can come to the fore. And at the end of the day, we don't get the story and democracy suffers.
Dan, does that story that Beck's been articulating reflect your experience?
Yeah, absolutely. I mean, I think that certainly over the last 3-4 years, it's a very obvious thing to say, but people have become less willing and less likely to speak to you and less likely to come forward. Now they've seen what's happened to people like Richard Boyle and obviously David McBride and Bernard Collaery and Witness K. I think it's really it's definitely had a chilling effect, and whether that's intentional or not, I don't know. I'm not a conspiracy theorist, but it's certainly, people have openly said to me, yes, I'm less likely to cooperate with you because I've seen what's happened to these people.
Kieran, there are plenty of people who say that, look, all of you guys are wearing tinfoil hats, that we're being a little bit paranoid here because we're not seeing people dragged off the streets and having their fingernails ripped out. We're not seeing stories having to go before a government censor before they're published. We're not seeing big chunks of black sprawled across our newspapers. Are we being a bit dramatic in this conversation?
I don't think so, and I guess I'll make 2 points. The first is that we can never know what hasn't been published because of the chilling effect. And we don't know whether it's subconscious or explicit in the discussions internally with a whistleblower, with the journalist, with their editor, with the lawyers of a newspaper or publication. And so we don't know what we don't know. And we've seen in recent months the power of truth-telling. We've seen the Brereton Report, the people who spoke to that inquiry. We've seen Brittany Higgins and others have spoken up about sexual harassment and sexual assault alleged in parliaments and other public spaces. We've seen the power of speaking up about wrongdoing, but we don't know what we haven't heard, what's happened that we don't know about because people are too scared to speak up because of the lack of protections for people who speak up. I think that's the first point. The second point is, I don't think, yes, we are, in relative global terms, a liberal democracy. We have reasonable rights and freedoms in comparison to many other countries, although noticeably Australia has dipped in a number of well-regarded global rankings around things like press freedom and civil space. But we can't take these things for granted. And the example I will use, which Beck is also alert to, is the Witness J case. Not a whistleblower, doesn't involve any journalists, but an intelligence agent who was charged and sentenced and sent to jail in the ACT in complete secrecy because of the operation of the NSI Act. And we didn't know about it. And we may never have known about it, but for a number of coincidences, some journalists spotted that a courtroom door was closed. They asked a few questions. Questions were asked in Parliament. There was a few different things, none of which was inevitable. And Beck and I both put in submissions to the Independent National Security Monitor, who recently reviewed this, and they had a public hearing. and we were all there, and some representatives of the Attorney General's Department, the intelligence agencies were there. And when they were pressed on this, their response was sort of, this was business as usual. What's the big fuss? You know, the law is there for a reason. A case that was held in complete secrecy. We're not talking about some elements of it being secret, some elements of it being closed. No one in the public knew about this case happening until it was sort of fortuitously found out. And so, yeah, I'm not a conspiracy theorist either, but to me, that was an extremely alarming example of the way these laws can be taken far beyond whatever would have been intended, and can be used in circumstances that are really anathema to our entire legal system, which is founded on openness. And it forces me to ask, you know, if that's happening in that case, what else could happen, could be happening? And I was particularly alarmed that at this hearing, representatives of government and of the intelligence agencies didn't recognise, or appear to publicly, you know, recognise what had clearly gone wrong. There was a sort of an attitude of, this is business as usual. When they were pressed on whether additional safeguards were needed, it was, well, that would be an administrative burden. Well, I'm really sorry if administrative burden sort of, it gets in the way of protecting our fundamental rights. But to me, that is a case, although not directly related to what we're discussing tonight, but it really highlights the risk to all of us when these powers go far beyond their initial intent.
I think if I can, something that was really interesting about the Witness J scenario, just for a second, was the journalists were responsible for finding out about it and bringing it to light. And when it finally got to the Independent Monitor and the government was really pressed, it said, oh, actually, we can tell you quite a bit about this case. Not a lot of detail, but we can tell you it's an intelligence agent. This is the kind of charge. This is the kind of sentence. So that over-classification, that not trusting the you don't need to know kind of placard paid off in the end. And there was quite a lot that we could know.
I think that, yeah, just very, very quickly, I know that we're obviously here talking about David and other cases, but yeah, the Witness J one to me is the most extraordinary one. That in a Western democracy, you can have a case like that occur, and it only comes out by accident. I thought was just absolutely extraordinary. But yeah,
and it does also raise the question of how many other cases like this actually exist that we haven't heard about.
Well, we don't know. We don't know, do we, Peter? No.
No, and the answer is possibly not many or none, but we've got no way of knowing that.
Can I offer a general comment, Peter? Any system will suffer if the human beings involved in administering that system are afraid to speak out. And we are seeing pages of black in response to requests for information to parliamentary committees and FOI requests, including requests made by our elected officials. We are seeing pages of black in terms of the silencing of senior public servants and retribution against those who say something that's not convenient or acceptable to our political elected officials. Our standing on Transparency International's Global Corruption Index has fallen and stagnated. The perception of corruption is consistently high amongst public servants. We have, as Beck just noted, no general data protection laws. We have no human rights charter. We have no National Integrity Commission, and we are stripping resources from our integrity oversight bodies. Our courts don't have a proactive oversight role, and nor should they. They apply law to the charges that appear before them. So in terms of where we're standing, we are not travelling very well on any accountability measure. And certainly the sense is that the trend is definitely towards an unaccountable state, which is a trend that should concern us all.
We have an awful lot of questions that are coming in from the audience, and I want to get to those in a moment. But there is one other question I really want to get to, and I want to address this to you, Fiona, and that's regarding the new Identify and Disrupt bill that was passed into law only a week or so ago, which includes an extraordinary array of or extraordinary capacity for the AFP to get into, hack into our accounts. Could you talk us through a little bit about about the implications for that new legislation?
Okay, sure. So as well as the suite of other national security laws that Bex touched on, in recent times, despite the warnings of the Law Council of Australia and human rights bodies, and contrary to the recommendations of the former head of ASIO, Dennis Richardson, the government has introduced new identify and disrupt laws, which allow the Crime Commission and the AFP to hack into personal computers and online accounts to disrupt suspected offences and gather intelligence. Now, it's entirely unclear why the AFP need those powers, and the potential scope of criminal activity captured by those laws is very grey and potentially enormous. They confer 3 new powers on the AFP and the Australian Criminal Intelligence Commission. The first is data disruption warrants, which authorise what's called offensive data disruption powers, so you can frustrate a suspected commission of an offence using a computer. It also authorises network activity warrants, which enable the ACIC or the AFP to monitor computer-related activities of criminal groups. And this is for the purpose of collecting information rather than investigating an offence to obtain admissible evidence. So that's a new power for the AFP. And it also authorises account takeover or lockdown laws, which enable those agencies to assume control of an online account suspected of being used in the commission of an offence. So it's entirely unclear why the AFP need those powers, particularly given the reports of the oversight monitors, and it's unclear why the lockout powers are needed and what crimes are intended to use those surveillance powers for. That law also expands the remit of the Inspector General of Intelligence and Security, so presumably that's meant to be a countermeasure to provide some additional oversight. But don't forget that the inspector is a body that's already under strain in terms of the paltry budget that body is supported by. And there is a great fear by those criticising these new laws that they are not necessary, and the proportionality of those powers is excessive, given the vast expansion of existing powers of both agencies.
And if I might add, a bipartisan committee of Parliament, chaired by a Liberal senator, made a suite of recommendations to ensure better safeguards in that bill. Half of them were ignored by the government, and that bill was passed through Parliament in less than 24 hours.
And without any real opposition from the Labor Party either, which I think is concerning.
Well, traditionally, and I have to declare my former candidacy for the Labor Party here, but traditionally intelligence and security is an apolitical approach by both parties, which you really have to have when you're looking at national security measures. But for the work of the Joint Parliamentary Committee to be effectively ignored, really undermines the value in the work of that committee, which does not currently include the Attorney General as a member. And that's significant because the Attorney General has the role of upholding the Constitution in this country, and her absence from that committee and the work of that committee creates a disconnect between the thinking of those members on that committee and their concerns and the Attorney General, who ultimately has to authorise activity and warrants and prosecutions, as we've seen in the national security interest.
There are so many questions here that I'm really, we could keep talking for hours on all of these subjects, but I really do need to get to some of the audience questions. And the first one I'm going to raise is from AJ Brown from Griffith University. And it's a rather intimidating one about whistleblowing, as you'd expect, and I'm going to offer it to Kieran. AJ's got 2 questions regarding the public interest, the Commonwealth Public Interest Disclosure Act. He asks, isn't the biggest problem for anyone in defence or an intelligence agency that intelligence information, on the absolute broadest definition of that term, is never able to be revealed to the media and receive whistleblower protection, even when the equivalent information, like unlawful killings, for example, revealed by any other federal official relating to any other context, would be protected if it was ultimately revealed to the media? Surely that's the key issue.
Yes, I would agree with AJ there. I mean, AJ is the doyen of whistleblowing law in Australia, so I wouldn't be bold enough to disagree with him. But I think, there are a number of issues with the PIT Act. What's extremely concerning is that the Moss Review and Independent Statutory Review in 2016 highlighted a whole range of limitations and reform that was necessary. 5 years later, we haven't seen a draft bill. I think that is extremely alarming, the delay that's been seen there. But as AJ says, intelligence information is so broadly defined, and there's an almost complete carve out in the PID Act for intelligence information that it's extremely hard for a whistleblower to speak up lawfully to the public in the case of intelligence information. And that's the difference we see, for example, between the McBride case and the Witness K case. David McBride at least is able to plead a PID Act defence to the charges, whereas Witness K pleaded guilty. And one reason, I mean, I obviously wasn't on his legal team, I can't speculate, but I would assume a core reason for that is because intelligence agencies are almost entirely carved out from public disclosure under the PID Act. So you could have, for example, an ASIO officer on an operation entirely unrelated to the operation commits cold-blooded murder. If another agent wanted to go to the media about that, having been stymied internally, they couldn't. There is absolutely no avenue for external disclosure in the context of our intelligence agencies in relation to intelligence information. Now, that, again, it may seem like a conspiracy theory. You might think, well, surely there's internal checks and balances. And sure, in 99% of the cases, hopefully those internal checks and balances are sufficient. But what we know from experience, from unfortunately hard-earned experience, is that sometimes those internal checks and balances fail. The media play an invaluable safeguard role. And in the context of intelligence information, an extremely broad definition, as AJ says, that role is excluded. And I think that should worry anyone who's supportive of the maintenance of Australian democracy.
I've got another question from Isabel, who asks, according to the ADF regulations, all members of the military are tasked with protecting Australia's interests according to law. Now, with the prosecution of McBride going ahead, despite the Brereton Report stating that the prosecution of whistleblowers is not in the public interest, what does that say about our government and about what our government and military consider to be in Australia's interest? Fiona, do you want to take that?
Sure. Well, the military members and, for that matter, members of the AFP are not and should not be asked to form their own judgment about what, according to law, means in this case. And it's unfair to place a burden on individual members when they're giving instructions to follow the law as to whether it's a just law or not. This comes back to the question of us having the right laws in the first place. There's also an institutional temptation to use laws that allow for gathering of evidence and intelligence if they're available. You can't ask an AFP officer or an ADF officer, for that matter, whether those powers should be used or should not be used if they're lawfully available. So I think that's a very good question, and it does place those members in an invidious position when they have to form a judgment about whether something's appropriate or not. They should be entitled to observe the law and know what their lawful powers are, with checks and balances above them in terms of the use of those powers.
But it also, I think, speaks to the tension between those two public interests. On the one hand, the public interest in allowing our intelligence and security agencies to operate with enough, with classified information without risking that information being leaked to the public, and that other competing public interest for transparency and accountability and the capacity to blow the whistle when it's necessary. Yeah. All right. I've got another question. The authority behind the decision that makes decisions to classify documents must be accountable. For example, one senior public servant has been quoted as saying that Australian public are like hobbits. From the hobbits in the Lord of the Rings, and the public doesn't know what's good for them. Do you think the rationale of the person holding that authority should be scrutinised? Beck, shall I offer? Do you want to take that?
I just worked out what the reference was to. It's a suggestion that members of the public are living in the Shire, oblivious to the evil going on in the world around them. That's how I understand the question, right?
Yes. Yeah, I think so. Beck, do you want to have a crack at that?
I can. Look, accountability needs to be built into the system at every possible level. The consequences of classifying something are massive for democracy. We've actually just at UQ introduced a new system where you get to select how sensitive your emails are. And I know that system exists in plenty of other public institutions as well. So we're finding more and more insidiously, we're being asked to mark things as sensitive and things like this. In government, it's the same. I worked briefly enough in government to know that everything has that question hanging over it. You say that something is secret or top secret, the consequences of that are so vast that it's difficult to summarise. People could be sent to jail for handling that information incorrectly. Dan was nearly sent to jail just for receiving that information because David McBride collating it amounted to stealing something, and sending it to a journalist was receiving stolen goods. And then there's secrecy offences, and then there's, you know, the harm that could come from it as well. To think that there wouldn't be proper, robust accountability and scrutiny mechanisms over the system of classification is mind-boggling. So there absolutely needs to be something there. The question is what that should look like and who should be involved in it. And I know that you, Peter, at the Alliance for Journalists' Freedom have been advocating for a kind of task force where you can have more media involvement in that process of identifying what should be classified and what shouldn't be classified, and when something maybe can be declassified, because maybe something needed to be classified in 2010 and it doesn't now. So I think we should be open to thinking open-mindedly and creatively. Australians are very creative about new surveillance powers and new national security laws. Let's get creative about different kinds of scrutiny that fills that gap between going public to the media and don't worry, trust us, we're just going to keep everything secret and you don't know what's good for you. There are a lot of options in the middle there, and we need to get sophisticated about how we think about them.
There's a really interesting question here from someone who worked on Nauru, who writes that before working on Nauru, I had to sign a confidentiality agreement threatening me with 2 years jail if I contacted the media. I broke that agreement and became a whistleblower. I was not charged. Not in the public interest, I guess, thankfully. No whistleblowers from Nauru have been charged, as far as I know. So does anyone have any thoughts on that? Dan, do you want to have a go at that? Do you have any thoughts on the question of not charging anyone from?
It's obviously a little bit difficult to, without knowing the scenario and the circumstances, and whether, you know, the information this person imparted made its way into the public domain. In
general, I guess the question is if the Attorney General or if the Commonwealth, the Director of Commonwealth Public Prosecutions has decided that there shouldn't be any prosecution, then that's an example of the system at work.
Yeah, and look, that obviously goes back to what we discussed before, Peter. But ultimately, you know, again, this is all dependent on what one person thinks. It's totally arbitrary. You know, in my case, it never got to Christian Porter, who was obviously the Attorney General at the time. Never got to Christian Porter because the CDPP and the AFP elected not to charge me. It would have got to Christian Porter if they had elected to charge me. So thankfully, I think Christian Porter was probably quite relieved it never came to him, because that would not have been a nice thing for him to have to decide. But ultimately, someone somewhere made an arbitrary decision. I'm very happy, obviously, they elected not to charge me, but it was all dependent on the whim of someone sitting somewhere in an office.
Fiona, are you worried?
I think arbitrary is the key word there, isn't it? We shouldn't have these such consequential decisions, these decisions that have an incredible chilling effect on our democracy shouldn't be in the hands of an individual that can make an ad hoc decision one way or another. We need to have structures in place that more appropriately recognise and support and protect and empower whistleblowers so that they don't have to face the situation that the questioner was in, where they had to make this decision: do I do what I think is right and blow the whistle knowing that I face this potential prosecution? They shouldn't have even had to make that decision.
Yeah, so in other words, it may be that it's not in the public interest to prosecute, but it may also be that it's not in the political interest to prosecute.
And can I just quickly go back, just very quickly, Peter, to this whole question about the description of or the classification of documents as being secret or austize only or classified, or we as part of the Afghan Files, and I'll tell the very abridged version here, but we did a story on an incident that occurred where 3 Afghan men were killed. One of them was hiding in a haystack, another one was hiding under a pile of chaff, and another one was running away. They were all killed. They had no weapons on them. They had no ID on them. They weren't ID'd. They had no Taliban links. They had no radios. They had nothing whatsoever. A report was done into the deaths of those 3 guys, and the report gave it a total clean bill of health and said, they were all killed under rules of engagement. Now, we published a story about that and said, hang on, how can you possibly say this? This is not what... The person who authored that report has been highly critical of us on the basis that he classified that report. And I won't name who that person is. They're a person who has a role at a think tank, is a former Australian Army officer and now works at a think tank, has been highly critical of us and saying, I classified that report. How dare you unclassify that report and say that report should be unclassified? Well, I'm sorry, but I read that report and the Australian people should know. So this is what I mean by the arbitrary nature of who decides what's classified, what the Australian people should know, what's secret, what's osteo, what's classified, what's not. Sorry, that's just my rant.
No.
Peter, you asked me, and I need to disclose or act for government in a lot of these migration matters. So I can't comment specifically on whistleblowing contracts in terms of service providers on the RU. But what I can say is that the secrecy around migration matters reflects a similar pattern here. We have a pattern where on-water matters, remember, as they were described, were protected from disclosure and they were not subject to press briefings after a decision was made that the public would no longer hear about those details of boat turnbacks and other on-water matters. And that at the time, the public was content with that because there was a particular view in the community about asylum seekers coming to Australia. And there seems to have been a shift in that view so that the public, to my read anyway, are no longer content to have that secrecy around those matters, and more power to the public in that regard. But there is a broader issue here. No one wants their conduct to be scrutinised if they're a public servant or a member of the ADF or any other agency. No politician seeks to be or wants to be criticised for their decision and their inaction. But if public servants and elected officials need us and want us to trust the decisions that are being made in our interests, that trust is eroded when we see evidence of misinformation, of secrecy, of spin and obfuscation. And in a crisis such as we're in at the moment with the pandemic, in the crisis of cyber attacks, in the crisis of climate, we utterly depend on trust. It is the currency that government have. And if we see that government are withholding information from us, we lose trust.
So we've still got a few questions, but I want to go to the issue of solutions. We saw after the AFP raids, those 2 inquiries, one by the PJCIS and the other by the Senate, and both came up with some fairly sweeping recommendations for legislative reform. Is that the solution, Fiona? Do we need top root and branch legislative reform, or are there other ways of tackling this problem?
Okay, so there's some heavy artillery we need in terms of the machinery of accountability, and I've mentioned the National Integrity Commission, the Human Rights Charter, and a framework of protections that we need to have improved. And we could call on AJ to tell us what we still need to do in terms of whistleblower protection, but certainly we're down that path. The need is for a fine web of integrity mechanisms and resourcing so that we have a system that self-corrects and is continually looking to improve and identify risks of corruption and risks of abuse of power. And until we have a resourcing of that entire system, including the big artillery of a National Integrity Commission, we're swimming against the tide here, and the trend will continue towards a lack of accountability.
Beck, you've got some thoughts as well on solutions. We've been talking a lot about legislative reform.
Look, I'd second everything Fiona just said, and I don't think I could put it much more powerfully than that. To look at it a little more narrowly, I think, so that's the integrity kind of systems within government. Within the courts, there are these problems that have infiltrated the courts as well, and we need to renew a commitment to those basic things of fairness and openness, to actually have pressure, be it in the form of a public interest advocate or somebody in the courtroom testing what the government is claiming. But I know what we've really talked about and what's relevant to this discussion tonight, and David McBride and Dan, is protections for press freedom. The fact that nowhere in Australian law is press freedom mentioned, let alone protected, it sets us apart from everywhere else in the world, really. So that whether it's in the form of a Media Freedom Act, which I think is the clearest way to do it, or introducing more journalism-based defences to prosecution, which we have in the secrecy offences and nowhere else, which is problematic. And both of those inquiries came out and said journalism shouldn't be a crime and whistleblowing shouldn't be a crime, and we just need to make clearer in law that if you're doing the right thing, which is legitimate public interest journalism or blowing the whistle on government misconduct, you're not doing the wrong thing. You're not going to go to jail for that. And law can do that. Law can create an exemption and frame it nicely and be clear to everyone that you're not committing a crime if you do this.
Kieran, do you have any thoughts on the way forward, the way out of this, the way to improve things without damaging our national security, without damaging the capacity of our intelligence agencies to do their jobs?
I agree with Fiona and Rebecca, and I agree also that, like, Fiona's pessimism, if you can call it that, is probably fairly well placed. But to try and give it an optimistic perspective, we know what we need to do. We've had 2 inquiries that have laid out a whole suite of recommendations and changes. A number of these recent increases in state surveillance capacity have been accompanied by recommendations from the bipartisan Senate, bipartisan parliamentary committee, with recommendations for safeguards, against the backdrop of people like the Human Rights Law Centre and the Law Council and the Alliance calling for a range of protections and safeguards. So, if I can sort of borrow from another context, we've seen recently the National Summit on Violence Against Women, and a number of participants in that made the very salient point: we've had enough talking. We know what needs to be done in that context and in the national security press freedom space. We've had the parliamentary inquiries, we've had the reviews, all manner of stakeholders have made their points. We just need to see legislative action. And, it is extremely disheartening that 5 years after the whistleblower reform recommendations were proposed by an independent review, we still haven't seen those made into law. But we've got to hope that the legislative will comes along sooner rather than later, and we see these changes, and that leads us to a place where we have greater protections for press freedom. But just lastly, part of this is a broader underlying cultural point in government as well. The secrecy, and then the flip side of that is the freedom of information regime, the disrepair that regime is falling into. All of that, I think, goes to a broader cultural point in the public service. And so, although I think we really need these legislative changes, what we also need is a government that leads by saying, we want transparency. We are prepared to accept the embarrassment that sometimes comes with transparency, because as Fiona says, that leads to trust. We trust a government that tells us the truth and accepts when it makes mistakes and gets things wrong, but is honest and truthful about it. So yeah, I guess my hope, my glass half full hope is that we see those changes at both the legislative level and at a leadership level, and that improves the culture.
Fiona, I've got to ask you about the political will for the kind of change. I mean, I know you mentioned earlier that we have a tradition of traditional bipartisan approach to matters of security and national security legislation, but surely that is damaging when we don't end up with these kinds of oversights that we've been discussing being debated, the need for transparency, getting the kind of robust debate that it needs in Parliament. We end up with a state that is heading inexorably towards greater security and a lack of transparency and accountability. Surely, do you see the political mood, the political will changing at all?
It's a very good question. And I think we didn't see enough of that mood in the last federal election, but we may do this time. I mean, if you look at the number of community grants being misspent, the unlawful assertion of executive powers that don't exist, the subversion of fair procurement processes, these things people begin to realise don't only affect them and their right to have a swimming pool or a new sports oval, they affect the integrity of markets, they affect the way that businesses do businesses with each other and the government in Australia. And I think there is a growing realisation that integrity as a broad election issue is coming to the fore. It's coming into a moment of its own. And I'm very hopeful that come the next federal election, integrity and accountability measures are top of the scale, and people begin to realise how a lack of accountability actually personally affects them, not just by those seeking to push misinformation and tap into a disaffected public who are concerned about everybody, but by those political candidates who can be measured for their own commitment to accountability measures. Let's have a scorecard for political candidates and their willingness to commit to measures like national integrity commissions, like codes of conduct for MPs, like holding ministers accountable under the ministerial standards. Because at the moment we're seeing a great slide and nobody is held to account for this misuse of public funds.
I am going to hand the last word to Dan. We've still got some other questions from our audience members, but we're just not going to get through them all. And so I'm going to leave it with you, Dan. Do you see any evidence of things changing? What do you see for the future of public interest journalism in Australia?
Peter, I'm just a lowly hack and all I care about is my next yarn. Look, I'm slightly more pessimistic than Fiona in that I'm not quite sure whether it is an issue that resonates that much with the broader public. I hope that I'm wrong, and I hope that Fiona's right. But I think that, look, I think there's still just fantastic journalists out there, and this sounds like a bit of a motherhood statement, but I think there's still just fantastic journalists out there doing fantastic work. I know that I work alongside them, and I work for a boss who's absolutely wonderful and who backs me and the team that I work for in every day. I think as long as, there are those of us still out there fighting the good fight, I think we'll be okay. I'm slightly more pessimistic than Fiona, though, when it comes to whether it is whether it's an issue that resonates with the broader public. I have to say, sorry, Fiona.
Okay.
If we can not let Dan have the last word, because I think it's important to acknowledge all those who tell inconvenient truths with courage. And I would like to acknowledge the work of our extraordinary journalists, Peter, in bringing these stories to light, because that's what encourages whistleblowers to come forward. The protections, absolutely, but trusted journalism that reveals stories that we have to hear is so important for the health of this country. And I just take my hat off to you, Dan, and your colleagues for doing so.
Fiona McLeod, thank you so much for those comments. Dan Oakes, Kieran Pender, and Rebecca Ananian Welsh, thank you all for joining this conversation. The great frustration that I have is that we don't have another 2 or 3 hours to continue the conversation. There were a whole host of questions that I really wish we had the chance to address. Unfortunately, we just don't have the time for that. Thank you all, to all of our attendees. Thank you for joining the conversation. This webinar has been recorded and it will be posted shortly, and you will all receive an email once it has been uploaded. Ladies and gentlemen, from me, from the law school, from all of our guests, thank you very much and good evening.